So Beatrice is the chair of the WDI Legal Committee. She has a background in international law and human rights, works on various issues relating to sexual violence against women, particularly effective prosecution. She's currently working on a campaign to verify the claimed existence of help centres in India for victims of domestic and sexual violence. And this talk today is going to be about issues with the UN Endorsed 8th of March principles and the WDI legal response.
Today I'm here mainly as representative of the legal committee and coordinating our activities there. So many of you would have seen the publication of the WDI legal response, or rather the 8 March principles that the ICJ introduced with a lot of fanfare. So one thing to first say is that while the ICJ, the International Commission of Jurists, they are not an international body, they are, however, a very significant non-governmental organization. And I actually worked there once. So there's a lot of, I think most of us go through this, where organizations that we once looked up to and worked for are now doing, pulling this kind of, well, trick. So
I'm just really sorry because I've just managed to stop your screen sharing. So if you could put it on again, that would be brilliant.
Okay, 1 second.
Sorry about that.
No problem. Let me just. 1 second.
Oh, it was so perfect, and then I've messed it up. Yeah. Sorry.
No, that's fine. That's fine. No worries at all. Yeah. So so basically, the ICJ, however, is fairly influential, especially at the UN level, which is why, of course, we wanted to publish a response to this. We're still working on some final details, but it will soon be up on the WDI website. And its publication will be announced through the WDI newsletter. So do keep an eye out. And for those of you who are not at risk, it would be great if you would feel up to sharing it. It's about 5 pages long, but that's unfortunately how much space it took to analyze this stuff. But the reason I put this picture up is to say that this wasn't just the International Commission of Jurists. OHCHR was involved in signing off on it, the Office of the High Commissioner for Human Rights, the World Health Organization, and the UNDP, United Nations Development Program. So a lot of the very highly regarded international organizations were involved in the publication of these principles, and much of the uproar has been about Principle 16. I will get to that, is about decriminalizing consensual sexual conduct. So in our response, WDI Legal has primarily responded to 3 principles, 16, 17, and 18. Principle 16, as you can see, was on consensual sexual conduct, and essentially saying, well, even any prescribed minimum age of consent to sex must be employed in a non-discriminatory manner. But very disturbingly, at the bottom of this page, as you can see in the image, it says sexual conduct involving persons below the domestically prescribed minimum age of consent to sex may be consensual in fact, if not in law. This is extremely disturbing. As someone who used to actually work in the arena of family law and child rights, I can tell you that this gap between the 16 to 18 age range in law has already been exploited. So for example, in India itself, the age of marriage is technically 18. However, the law on statutory rape said 16. So there were a lot of child marriages carried out, even at the time that I was a student and at the time I was practicing, where children would be below the age of 16, and they would just say, okay, we're just getting them married, and but the marital relations would technically not take place, or they would claim that they weren't taking place. And of course, marital rape is also not considered rape. So child marriages were still carried out, the statutory prohibition didn't apply even then to young girls in forced marriages and in child marriages. So for the ICJ to come out and say something this reckless, to say sexual conduct involving persons below the prescribed age of consent may be consensual, is ridiculous and reckless. Of course, when we started discussing this in the legal committee itself, among members of the legal committee, we discussed the issue that do we really want to say all teenage sexual conduct should be criminalized? And that is a concern. Yes, there may well be teenagers who wish to engage in sexual intercourse. But the way to deal with that is to make it very clear that we're talking about a particular group, especially those of similar age, without a marital context, in cultures where there is some kind of conversation about sex during teen years. If they did want to make an exception to the prohibition on sex under 18 or under 16, it can vary between countries. The way to go about this should have been to make the exception as narrow and as specific as possible. That's not what the ICJ did, and that's what we're saying in our statement, is that if you were so concerned about teenagers engaging in sex, the fact that you went about it in this way is really troubling. Because, like I said, the fact that statutory rape is mostly defined at 16 in most countries, and the fact that marital age is legalized or marriage is technically legal after 18, there's already a gap. The 16 to 18 gap and whether it's actually criminal in that age has been an issue for child protection people for as long as I've known. It's been a debate in both in women's rights circles and in child protection circles, and lawyers have been trying to find a way around that. And I'm not saying that the situation is perfect, but the way that the ICJ went about this was disturbing. And I'm just going to skip ahead to this. The funny thing is, because of the uproar to this principle, there were several responses from the organizations involved. The International Commission of Jurists, they responded, as well as UNAIDS. And if you can see here, it is, I'm not sure if you can see because this is as large a screenshot as I could take. It says that criminal sanctions are not appropriate against adolescents of similar ages. So that's kind of the fourth line from the bottom. UNAIDS, in their response, were able to make this distinction that the exception should only apply to teenagers of similar ages. And yet, in the published principles, which apparently went through many rounds of review and was endorsed by the OHCHR and by UNAIDS and by the World Drug Council, this specification does not appear. One thing that I do have to say about these principles is that the whole approach is don't criminalize things, don't use criminal sanctions for X and don't use criminal sanctions for Y, and we need to use criminal law as less as possible. And in the backlash to the principles, as usual, some of the rhetoric has also been about carceral feminism, because apparently now criminalizing conduct is oh so bad. And I think it's important for women in this webinar and for us to also be aware of, well, human rights sounding language. Of course, all of us are very aware of how it's being used to get rights for men pretending to be women, but the idea that criminal law must only be used very sparingly when it comes to drug offenses, when it comes to trafficking, when it comes to prostitution, this is part of that push, is that to say, don't criminalize stuff. Don't criminalize commercial sex. Don't criminalize anything. And it might be a good idea for people to really question, but hang on, what standards are we using? Yes, we used to criminalize a lot of, well, unnecessary stuff many years ago, but that doesn't mean a lot of other conduct should not be criminal and treated as such. Sex traffickers get a maximum of 5 years if they're caught, and we all know how difficult that is. But currently, the ICJ and the entire international infrastructure is going full steam ahead to decriminalizing a lot of problematic conduct. Ironically, all of this conduct is stuff that hurts women. And a lot of women also, of course, support this trend because they're afraid of carceral feminism, and they're afraid of an overcrowding in jails and how most people are being imprisoned for nothing. There are a lot of myths surrounding criminalization, and the fact that all of the international organizations are now going on this rampage of being very, very concerned about what's criminalized should be a red flag, not just in this context, but in many contexts. The second principle that we addressed and was problematic in the 8th March document is this, Principle 17, sex work. Again, we are all aware of the current liberal position on prostitution, where they call it sex work, and they say that it must not be criminalized, it must be legalized. And the ICJ has also gotten on this bandwagon, who say, who have said that where there has been sexual conduct for financial or material benefit under fair conditions, without coercion, force, abuse of authority, or fraud, then it should be fine. This is, well, frankly ridiculous, because aside from force and coercion, the most powerful influence in all of our lives is money. So obviously, if you say under fair conditions, what fair conditions? Is the government going to verify if all of these women are completely consensual, if they have other choices? That's not been stated at all. I do think it's important here to mention that the position we've taken is to not just assert the radical feminist position. We've also said, look, if this is what you're arguing, then be able to defend it. You have said fair conditions, you haven't specified it, because we're trying to engage with them on their own terms to say that even by your own logic, this makes no sense, right? Because otherwise they can just say, oh, well, we don't agree with you. So our starting point is not to say, okay, this doesn't exist, or you should just call it prostitution. Our tone and the approach in this letter is, even trying to follow your logic, this does not either make sense, and where you think you've made a very bold statement, you haven't specified what these fair conditions are, and you haven't specified how you're going to safeguard vulnerable women who need money from these kinds of conditions. The third principle that we have addressed is, of course, Principle 18, which talks about sexual orientation, gender identity, and gender expression. So the most relevant part of this is the third paragraph, which talks about practices aiming to change or suppress a person's sexual orientation and gender identity, etc. As we all know, this is what they call as conversion therapy, and this is what they try to silence therapists and medical professionals who may try to give gender confused kids an alternative. So within the statement, what we've said is, first of all, this does not apply to LGB, because the second part of this principle says medical care should also be made available, except that LGB people aren't asking for medical care to be who they are. They're just asking to, well, be left alone and to have their relationships legally recognized. So, well, as well known, they lump it all into one. And they've tried to say that this is an issue of SOGI, sexual orientation and gender identity, when in fact, it's just an issue that is relevant to gender identity. So the response on that basis has just been, you're, again, post-steaming, you are deliberately lumping a concern or an interest that is unique to one group, and you're asserting that sexual orientation also uses that. Minorities in sexual orientation also need that, such as medical procedures to be proud of their identity, which is not a thing that LGBT people ask for. So finally, yes, like I had already presented this earlier, the UNAIDS report, UNAIDS has responded to the backlash against the 8th March principles. The ICJ itself, just about a month after they released the first set of principles, they came and said, oh, we're not against criminalizing sexual conduct between we're not decriminalizing all forms of sex, except our entire approach there has been, if you were going to talk about teenagers, you should have been very specific that it's between similar ages. And your principles should state the conditions under which those children will be protected. So, of course, coercion can also exist between a 15-year-old and an 18-year-old. Right. So when you say similar ages, what age range are we talking about? Are we talking about the exact same year? And if you do want to say that criminal law should not apply, are you going to at least put in place some kind of process for verification that teenagers who engage in sexual conduct are doing so fully consensually? All of this is the responsibility of an organization like this that puts out these principles, and yet that they have completely abdicated. So we will release the final version of the statement very soon. And we're looking forward to hopefully having it shared, as well as there is a letter that Joe has already talked about, the statement in support of Reem Al-Salem. The legal committee is also working on another statement where we've particularly addressed AWAD's stupidity, because the current statement being circulated for signatures is a generic statement and of support for Reem's work, but we are also trying to respond specifically to AWID because it's time that, we took the fight to them basically, and we can't just stay back and say, okay, she's doing her job, leave her alone, but also that, they're being insane. So yeah, that's another thing that we've been working on, but this, the WDI Legal's response to the 8th March principles will soon be made available. Some people asked how they can support resisting these principles. Like we said, the statement itself will be published on the website, but we are also discussing whether we can, say, run a couple of open events, because one thing that we've decided, we kind of agreed on with the legal committee, is that at least some of us, we have to be open and we have to put our faces and names out there to resist the UN. So we're thinking of other ways to push this statement and some of our other submissions up. Like I said, there will also be a response to AWID. We're also working on responding to the ICC, is currently fudging the definition of gender in the court. So yeah, we, as much as the people here can advertise, or if you have any ideas to, again, elevate our response, because the NGO community is so strong and they mostly just ignore us. So that's anything that anybody can do to help. And of course, if there are lawyers in the crowd who are interested, just reach out to us at legal@womensdeclaration.com, and we'll be happy to have them also on board.